If you're buying a house, then you'll need to put down a security deposit when you sign the purchase and sale agreement. The purchase and sale agreement is essentially the contract between the buyer and the seller for the sale of the house. So the purchase and sale agreement will say that if the buyer defaults, he'll lose his deposit. The deposit will be given to the seller. The deposit will be anything up to 5% of the purchase price of the property. So occasionally the question will arise, or a client will ask me, in what circumstances would they lose the deposit? What would constitute a default on the part of the buyer? So generally, two things need to happen before the buyer is 100% obligated to purchase the property. First of all, the seller needs to have marketable title. In other words, there are no legal problems preventing the seller from selling the house to the buyer. And then second, in most instances, the buyer will need a bank loan in order to purchase the real estate. And the agreement will say that unless the buyer can get this loan, the buyer is not obligated to purchase the property. However, once the bank commits to giving the loan to the buyer, once the bank issues a commitment letter, the buyer is then obligated to fulfill the terms of the contract and purchase the real estate. Okay? So you put the deposit down, and then if the seller has good title, the seller can sell to you with no legal problems, and the bank has committed to you, has essentially told you it's going to give you your loan, you're then obligated to buy, and if you walk away, you'll lose your money.